The disability application process for short-term or long-term disability benefits is probably one of the most challenging parts of the entire process when someone's seeking benefits, whether they're on claim or denied. It's always going back to what was that initial application. And in this video, Steve, I want us to talk a little bit about what that application process is, how do we help claimants to go through that process, and why it's important to have an attorney or an advocate be on your side when going through this process. Because as you know, these disability insurance companies are often looking at paying out hundreds of thousands of dollars to a claimant, and it's right from the get-go that they're most looking to not pay that claim. So, let's start out of the box as to why it's not just as simple as filling out those forms that the disability carrier sends to a claimant.
Well, the forms seem simple enough, self-explanatory, but they are set up in such a way to see if they can find ways to punch holes in it. I think even the attending physician statements you may get on a monthly basis, if you look over, you notice it doesn't really a lot of times speak as to what the conditions may be or give the doctor a lot of room to even express opinions. So these forms, they may be asking for simple information, but something as seemingly minuscule as possibly putting the wrong date of disability can completely affect your claim when they go and they evaluate, were you working that day, were you doing your duties. So it may seem benign and not too problematic or in-depth, but the companies are really from the get-go trying to find a way to either figure out how they can deny a benefit if possible, or they're even setting up, if they're going to approve it, what's the quickest way to try to get you back to work so they don't have to pay.
The return to work, aka denial date, is what we usually see. So let's back up a second. There's two types of policies that we help people with, or two types of law. There's the ERISA governed policies, which are usually the employer provided benefits, and then there's the individual disability policies, which are the ones that people either bought on their own from an agent or they got through an association like an American Dental Association or General Surgeons Association or accountants, things like that, which are not governed by ERISA. And there are significant differences in those two, but at the end of the day, the way that you apply ends up being the same. So we won't necessarily talk in this video about the ERISA nuances, which we've done tons of videos on that. So let's talk more generally about applying for benefits. Now, when we were talking about what do we really want to talk about in this video, we were saying how most of our clients who apply, the ones who get hit by a bus or have some real catastrophic injury, those are no-brainers, and those are far and few in the claims. The real claims that happen are the people who have been working for years, have chronic conditions, and then apply. Yeah. And as you just said about a minute ago, was what is that date of disability, and when do you reach the point to say, I can't do it anymore, I'm now disabled as defined by my policy? What is it to look for, and how do you plan for that?
It's very hard, like you said, unless there's a easy to point to definite period of disability or a cause. You get in a car accident, something like that. It is hard, especially under the employer-provided policies, because a lot of times you don't have the luxury of taking times off or transitioning out of work in a process before you call it quits. And a lot of times the insurance carriers will look at that as, well, the day before you've been working full time, there didn't seem to be any issues, and they kind of use it against you that you've tried to work through it. Whereas in an individual policy, if it's a business owner or something like that, there's a way to try to, like you had said, plan for the disability, prepare, because you really have to prepare for the idea of disability. So it's really kind of hard to sometimes pinpoint that, not to mention, you may say my last day of work, I just couldn't take it anymore, it was this day, but if you hadn't been to the doctor in a month or two or anything like that, then you don't have treatment around that time that'll justify or verify the doctor saying, hey, I think it's time, you need to think about filing for disability. So it can give the insurance company a route and a road to just basically say, hey, you weren't treating at this time, there's no one verifying the disability, you were working up until the day you quit, so what happened?
Right, and we see that all the time. And part of the service we do is for the people who haven't filed yet and they contact us is we work through and basically put a plan in place. And you have to have a plan and work with you and your treating doctors to make sure that the proper medical support is there, because we have seen thousands of disability denials that weren't properly supported. Yep. And I can assure you that the chances of your doctor knowing on his or her own how to properly document your file is slim to none. How often do you see records that are just, they're not going to cut it and you're going to end up with a denial? Yeah. So I think the first most important point is you got to have the medical support. And if you don't have proper medical support, you don't have a physician who's going to get your back, or support you and say you can't do A, B, C, D, and E, that you don't have any shot at all to get approved for benefits. So what's the next important thing you think? You have your medical support in place. What do you got to look at in the policy in terms of timing as to when to file a claim to make sure you even have coverage?
Well, one of the biggest things, especially when we're taking a look at group disability claims through an employer, is how long you've been working for the employer. But not only that, because we have seen where you could be there for 5-6 years and they never really had coverage, but when you became eligible under the disability policy in and of itself. Most group disability policies from employers will require you to have been actively covered under the policy for 12 months before filing to avoid any potential pre-existing condition. So sometimes you do get circumstances where people are suffering through it, and we've seen plenty of times when you apply on your own that they've missed the date, and sometimes it's a week or two difference, and the insurance company has a clear-cut legal argument based on the policy language that they don't have to pay the claim. So it's a matter of knowing when you became eligible, plus certain things as elimination periods, notice of claim, and proof of loss provisions that are contained. So there's a lot of dates and timing that goes into play.
Right. When a claimant does their own application and we don't have the opportunity to write that application literally with them, we're married to that application. But how often do you see where a person says, I have back pain and that's what's stopping me from working, and they forget to talk about any of the other issues they're dealing with, their cardiac issues, their psoriatic arthritis, their shoulder, their knees, whatever it may be, and now it doesn't get considered.
Yeah.
Or what about the issue about if they have some psychiatric issue, which is secondary to everything that's going on, but the disability carrier pushes that as primary, and what's the downside to that if that happens?
Well, the downside if they push it, mental health to the primary, I've really yet to see, maybe a handful of times in how many years of doing this do you see where there's not a limitation for a mental health condition. That's anywhere usually from 12 to 24 months, where if they determine you're disabled because of a mental health condition, however the respective carrier defines that, they only have to pay you 24 months in a maximum. I've worked on many appeals and many claims where the issue is the person waited when the insurance company said we found you disabled because of depression, and they waited till it was almost over, the claim was over, and now we're trying to argue no, there's all these other physical conditions. There's a common misconception, I think, and I tell people that disability claims aren't like a workers' compensation or a personal injury where there's one event or one condition that's causing your claim. Anything that's going on with you has to be reviewed to determine your overall total functioning. Like you said, you see a myriad of different conditions that all kind of play into it.
All right, let's talk about, you talked about these forms. You didn't mention it, but often they're ambiguous. They're drafted to be kind of benign, like geared towards not having a lot of information, so the disability carrier could almost come back and say, well, we don't have enough information to support your claim. So we talked about the medical. Now you have the occupational information. I know when you do claims and when we do applications, there is never enough space there to fill in what we need to do, and we often custom write paragraphs or pages of additional information to explain to the disability insurance company what the occupation is that the person was doing. Why is that so important?
Well, the occupation, it's all tied back as how your condition is preventing you from doing the occupation. And I find, especially in reviews as opposed to a private policy and an employer-provided group policy, that the insurance companies review those things differently. And the vast majority are going to be group employer-provided policies just by sheer volume. And in those, more often than not, regardless of what your occupational duties are, what they'll try to do is apply a national economy standard. Well, they'll try to ignore what you have to do specifically for your job and see how it's done in the general workplace. But more often than not, it seems, even when they're reviewing it and they're sending correspondence or in the event of a denial, they strip it down to the bare bones Department of Labor physical demand level. How many times have we seen that, okay, you were a quote, nuclear engineer, that's a sedentary job, we feel you can do sedentary work, so we don't think you're disabled. So they really try to just minimize it, and that's why when you see the attending physician statements, can this person sit for how long, things like that, they're trying to set up physical demand levels when someone's occupation goes well beyond the ability to lift negligible amounts of weight daily.
Right. How long can you sit? How long can you stand? How long can you walk? Can you crawl? Can you reach? Many of the things that are not really relevant to whether or not you can do your job, but it's important how they're communicated back to the disability carrier so you don't put yourself in a position where you can get denied. The other thing that a lot of companies like to do that, of course, we assist with when we're representing somebody is, what about when they want to come see you? as a claimant and interview you, or they want to do a phone call with you. What do you even have to do that is the question. And so sometimes I tell the carriers, we're not doing that unless the policy says send us your questions in writing. We're not having anything misconstrued by you. But oftentimes you do need to talk to them, and that's something that we always participate in and walk the client through that process and make sure that everything is communicated and documented the way that it really came out, so that there's no other stories from the disability company. While we did talk about the medical, oftentimes these disability carriers, will try to go directly to the doctor. And how important is it to make sure that the disability company is getting the medical information and how it's being communicated in these attending physician statements? What's your role from that perspective as an attorney?
Well, usually the biggest thing is making sure the doctor's not going to send anything directly back to the insurance company, especially in any forms, because a lot of times the forms, especially if it's a physical condition, and those questions about the lifting, sitting, reaching, whatever it may be, a lot of times they don't give the option of never. It's always some minimal level. They don't even give the option to say that the person can't do it. So sometimes doctors are just checking off the boxes what they deem to be the lowest category, which still falls into the ability to work. So it's about making sure those are coming back. It's being presented well. Not to mention too, I think sometimes doctors, they may not understand that a policy may be based on your ability to do your job, and they're thinking disabled in a total sense of it.
They're thinking disabled from activities of daily living, the ability to bathe yourself, walk, get out of bed, and the normal activities of daily living.
It's making it clear that this is occupationally based and specific to that. So you always want to make sure those are coming back to you. And it's another reason why we always make sure we obtain medical records, not only to make sure that they're documented, but many insurance companies will, for a while, they'll collect records on their own. And they almost lead someone to think, oh, they're just going to get these records, they're going to get these records. And then if a denial happens, they'll say, well, we didn't get any updated medical records. At the end of the day, it's your duty to provide. So you never rest that they're going to go ahead and do this. You could tell them, I have all these other doctors. Doesn't mean they're going to get the records. So it's a matter of also getting those records, seeing how they're documented, and then presenting them to the company as well.
And the other thing that's complicated as well, which we're not going to go into detail in this video that we have, is on those private individual policies when you're a physician or a lawyer, an accountant, a business professional, and the disability carrier wants to determine what your occupation really was, and they start looking into your calendar, your production reports, your client list, all kinds of additional information. They really open up Pandora's box and trying to get information, and we're able to monitor that and limit their ability to get certain information because we know what they need and don't need. So we do have another video about doctors, physicians, and business professionals dealing with individual disability policies as to what you do and don't have to provide, and that's something that we've done literally thousands of times for doctors. So, one of the other things that people always say, well, I guess I can do this myself. What does it cost to have you involved? And as you know, we offer very flexible fees, whether it's an hourly arrangement, a contingency arrangement, a flat fee arrangement. We want to be your partner in your claim. We want to help you to get paid your benefits, and basically, like our motto is, as you've seen from our book that we've published and on our website, whatever it takes to get you paid, the most legal and legitimate method of doing that, we're going to assist you so that you can maximize your policy. So we always offer a free consultation. We recommend that you provide us with a copy of your policy. We'll set an appointment, we'll review it, and we'll let you know immediately whether or not we think we can assist you. We look forward to speaking with you.